Today, I think don't seek any adjournment as there are lesser number of cases. Unless it is very, very urgent.
Item number 3, Lord.
Item number 3.
In this case, I appear for the respondent, my lord.
Yes.
Yesterday, the counsel informed that he has some personal difficulties. Otherwise, the urgency in the matter. The petitioner has not been able to join here at Gauhati. And her child has been admitted to the St. Mary's College. Sorry, school, my lord. So, my lord, she is in difficulty, my lord, because she is neither here nor there.
Tuesday.
My lord. Deeply obliged.
Witnessed.
Deeply obliged.
Submit for on behalf of the appellant and agreed to by the land council for the respondent. Let this matter come up for consideration on
13-5.
Deeply obliged.
Any
This is
request?
that mutual transfer regulation.
Yes, madam.
Is that the matter?
Yes, madam.
All right. Yes.
Daily list for this. We have request.
Wait, please, my lord. My lord, I'm praying for listening for pending DTP, but it's already listed on the hearing list. My lord, may take it up in the regular list if possible. It's not a problem.
Mention on Monday, we'll see.
My,
Mention on Monday. We will see.
my lord.
We are not promising you anything.
My lord.
Yes.
May I please also. I
Yes.
just mentioned for listing of a writ petition of fresh writ petition filed yesterday, my lord. It's regarding, my lord, we have challenged the Central Administrative Tribunal order, my lord, where our original application has been dismissed. Which
On what issue?
My lord, on transfer, my lord. The petitioner is a 59-year-old scientist, my lord. He is worse of retirement, my lord. He was transferred from Bhopal to, my lord, Tamil Nadu. My lord, the difficulty is that, my lord, he has been assigned a project by the National Science and Technology, my lord, which, my lord, is prohibit him to leave the project in the midway, my lord. Otherwise, he will be penalized.
That your employer must have understood.
My lord.
That your employer must have considered.
Hmm.
Because if it's a national project, he is the employer of the petitioner also would be amenable to those restrictions.
My lord, he is researching on the, my lord.
Anyway, we will hear you. We will hear you. It's just a question of,
My lord,
giving you precedence.
my lord, he is
You have filed this writ petition when?
my lord, yesterday, my lord.
Yesterday. So it will come on Wednesday. Wednesday, how many matters? 7. 27. Thursday? Huh? Wednesday. All right, next Wednesday.
I'm deeply okay.
13. Daily list orders item 1.
Okay.
Yes, sir. What to do, bond is the term, feeling happy on the requested that they're waiting no other explanation except that.
Now, why do we show indulgence to fence sitters? Why do we show indulgence to fence sitters? You're not saying anything.
No, no.
You're only dependent on the benevolence of the bench.
No.
I think the order passed by us has to have has to pass the muster of the judicial scrutiny of the Supreme Court itself. The law is otherwise. You have not given any reason. Is that the reason?
That is the reason. And some poor people could not afford anymore. I think they can be expensive, but
All right. We'll deal with this aspect of the matter when we hear it on merits. We might not give them the same benefit. But let them come before us.
Yes, my lord, but otherwise they have not explained the delay, my lord.
We have followed.
Yes, that is that. And only they are fanciers. That is my main contention, my lord.
And 303 days.
303 days, my lord.
Without an order by us, you go and approach the government. Go and approach the government, approach the department, if benefits have been given. And if they refuse, then you file another writ. But here, we don't find any good reason to condone the delay of 303 days. And otherwise also, we are not going to give you the same benefit. It was limited to the number of respondents there or number of petitioners, I don't remember.
Lordship, can you only they are presence of the same boat?
I don't know whether you have followed our observations. We say that some concession was given by the department with respect to accommodating certain persons.
Yes.
Because they were already working and they had experience in the burn hospital.
Lordship, they are the same persons, Lordship.
But you were not there before us, no? So the concession was made by the department on our persuasion, and then we closed the chapter. You get sitting now, you do one thing. This is an advisory from the bench. You go and approach the department that, well, on these grounds, you have given it to them, give it to us. If they refuse,
Yes.
then there will be a fresh cause of action. You will not be required and come immediately. So by a fresh writ, then you will not be required to explain 303 days delay. All right. So we are discussing this application. The delay application is rejected. Now, approach the department. If they don't accommodate you, that would be a fresh cause of action.
Item number 2.
Yes,
It is a loss. My lord, in a 484 days delay, my lord. We need to find this appeal, my lord.
All state respondents.
accept notice on behalf of the respondents. There is an application seeking confirmation of delay of Ms. Sharma, learned counsel for the state, accepts notice on behalf of the respondents. Two five, man.
Give a slip, he will record the note.
So and so. The learned counsel for the respondents submit that they shall respond to this petition by the next date. Let such affidavits in opposition be filed positively by the next date. We notify 3 weeks.
24(6). For admission, item 4.
Yes.
Lord, there is nothing wrong in the order under appeal. But there is wrong in the order against which we, actually, my lord, to be honest.
Now, just a minute. Now, one minute. Before we look at this,
Yes.
now there was some order passed in the title suit.
No, my lord, there was an appeal before this honorable court against refusal of injunction. There, this honorable high court passed an order of status.
Just a minute. I'm on a totally different aspect. We are not on facts at all.
Okay.
Whether in the first instance was a petition maintainable. If it was maintainable, if the petition was under Article 227 of the Constitution of India, then no appeal. I'm on that. I'm on the proposition of law coming since 1970s, 9
Yes.
judges bench,
Yes.
Mirajkar.
Yes.
So we are not on facts. We are
Okay.
not on the evaluation of the judgment of the learned single judge. Whether appeal is maintainable.
1 second, my lord, let me see.
If it
whether
is
it was under
227.
20 petition for national court.
I think you would not have gone in 226. You would have gone in 227.
No, my lord, what has fallen from your lordship is correct. I'm not disputing that proposition. Now, what we are agreed by is in a contempt proceeding, whether any further orders can be passed.
That is something else.
Ah.
Now, if
No,
the,
we assail that order.
if the base, you may have,
Ah.
but then contempt petition, whether contempt was maintainable, whether we can say anything, everything is bad.
No, my lord, the learned single judge, the order.
He could not have modified the order.
No. Yes, no, Lord, the learned single judge, pursuant to which this appeal arises, has given the liberty, sort of a way, file an appeal. This is not maintained.
But we can't give you the liberty beyond the statute, no. we can't ask you to file an appeal against an order passed under Article 227.
No, Lord, what all that I'm trying to say is.
I think you have followed.
I follow.
The difficulty is that we are not able to concentrate on the facts of this case for the reason that this entire thing is misconceived.
Yes.
It's misconceived. You'll have to check up from the records whether the
Original petition.
the parties approached the High Court in the first instance under 226, 227 or only 227.
Yes.
Beyond that, we don't know.
No, if it is 226 and 227, then no difficulty.
That
Yes.
practice is
The
only,
line of
that
judgments
practice-
are there.
no, that practice is only in the state of Bihar.
Okay.
Here you specify either 227 or 226. Now this court I mean, in different jurisdiction has authored a judgment that even if it is passed under 227, but the tenor of the order is such that it appears to be an order passed under 226,
226.
appeal would lie.
Yes.
So therefore, you first satisfy us on that count.
Well, I'm slightly handicapped because that original petition is.
Find
not-
out and tell us before that. Otherwise, we will hold everything to be bad.
Huh. Now I followed. And in fact, Mala, there is a Supreme Court judgment also where Honorable Supreme Court has said, even if the petition is under 227, if the language, tenor of the language is such, then it
Correct,
appeal would lie.
That we have done.
Yes.
We have also done that.
First order is under order
43 Rule 1R
rule one.
by appellate. No, my lord.
No,
I think what Honorable Justice Chaudhary want to say is, my lord, the
Yes,
first
okay.
order, there was an order of status quo under order 43 Rule 1R. Now we allege violation of that order.
And then a contempt.
And then a contempt. In that contempt proceeding, my lord, a learned single judge of this honorable court,
It was
only under FAO.
order 43 Rule 1R. Yes.
Very good, very good.
Yes. Now, my lord, only point therefore is whether in a contempt proceeding any further order can be passed by the court.
You have judgments
Yes.
judgments on both sides.
Midnapur, my lord.
Midnapur is one, but it says that if it is to be executable, minor changes here and there.
Is a different thing, yes. But Midnapur is clear, my lord. If an appellate provision is there, in fact, my lord, let me tell your lordship very frankly, my lord, I wanted to withdraw the appeal, my lord. Because
that is a
a
better-
learned single judge of the honorable, I said I prefer an appeal. Then a learned single judge of this honorable court said, no, we can entertain this petition. Then coincidentally, my lord, the matter came before another bench.
If you notify the according
An appeal arises out of the contempt order.
according to the consequence of any contempt petition, we modify the earlier order can so to the experience from the date of present order, no construction order from renunciation of corporation of any from
He আগৰ petition to নাই কেনে মই দিব পৰা নাছিলো।
originally order under FAO. First appeal against order. So there is no 226.
Correct. There was an FAO, there was violation of FAO, then we filed a contempt petition. In the contempt petition, my lord, the learned single judge issued appointed a commission and passed an order. Against that, we preferred this.
Later. We have heard Mr. K. Chaudhary, learned senior advocate for the appellant. This case originates from a property dispute, which was the subject matter of a title suit number 166 of 2022, preferred by the appellant against the respondents before Civil Judge Dibrugarh, involving a claim regarding a right of preemption over the suit property. The appellant had sought an injunction to restrain the respondents from taking possession of the property. The injunction petition was refused. The injunction petition, the request for grant of injunction was refused on 17/11/2022 on the plea that the respondents were already in possession of the property. In the FAO number 58 of 2022 preferred by the appellant, this court on 16/12/2022 modified the order and directed both the parties to maintain status quo with the suit property until the title suit was disposed of. A further direction was given for expeditious disposal of the trust. Next. Malik, you're appearing now?
Yes.
Suddenly you have appeared?
Respondent for the respondent.
So you want to respond to this?
Yes, Lord.
All right. Alleging that the respondents violated this status quo order by resorting to construction, a contempt petition was filed by contempt petition C number 215 of 2023, in which notices were issued and the status quo order was reinforced. After hearing and a local inspection by a court commissioner, the learned single judge on 7/11/2023 passed an order which had the effect of modifying the order passed in contempt. The order impugned in the present appeal amounts to modification of an earlier status quo direction to the extent that no further construction, modification, renovation or alteration of the property shall be carried out from 7/11/2023 onwards. But permitted the respondents to continue their existing business without changing the nature of the property. The review petition against this modification was dismissed on 17/12/2024 with the liberty to file an intra-court appeal. Hence the present appeal. Mr. So-and-so learned counsel appears for the respondent. Hence the intra-court appeal. The appellant herein contends that in contempt proceedings, a court cannot re-adjudicate factual dispute or modify the original order on merits. Method protection.
My lord, paragraph, page 411.
Paragraph, what did you say?
It says, my lord, in a contempt proceeding, no further orders can be passed. At Roman, I think 6, I have highlighted, my lord.
Okay.
Order 29. How can that be a contempt petition?
Well, we have serious, objection to the entertaining of the contempt petition.
No, my lord, we are against the order passed in the contempt.
That's why I'm saying, even if it is a contempt, then the provision will be something else.
No, my lord, Midnapur says if it provides for.
The court cannot re-adjudicate factual disputes.
Yes.
Modify the original order on
Yes.
merits. Mr. So-and-so, who has appeared on behalf of the respondents, seeks some time to respond to this, to respond to the memo. Let the requisite affidavit on behalf of the respondents be filed positively by the next day. Re-notify. Give your name.
Yes, I am.
Yes, I affirm.
Give your slip.
Lordship, verified. So,
22nd June.
Impression that
22nd June.
petition under
No.
27 aspect.
No, actually, I was also slightly handicapped because the petition we have not annexed.
No, the order says this is an application under order 43 rule 1.
Yes, yes.
22/6.
In fact, my lord, we wanted to withdraw this, but something happened. That's why, my lord, it continued.
But we'll see on the next day.
My lord,
Item 5.
May I please your lordships? May I please your lordships? My senior, Mr. Sharma, is out of station, lordship.
Did we not make a request to you that today there are lesser number of cases? So if you seek time, then we'll be absolutely jobless in a short while.
Lordship, though we have
Of course,
requested.
we have some other, program coming up. For that, we had lesser number of cases, but then, anyway, Only clear. Will you appear for the respondents?
Yes, your lordship.
तुमको पता ही नहीं है what we're telling.
But
You should accept them. You have, to our estimation, you have a weak case. Where is your senior? Who is your senior?
Mr. M. Sharma, Lordship, he is out of station.
Again, on account of absence of Mr. M. Sharma, learned advocate, who has to address this court on behalf of the appellants, the matter is adjourned to after 3 weeks.
Much obliged, Lordship.
Deep your pleasure.
5-6. Item number 6.
Yeah, please, Chair also. This writ appeal is against the order dated 15/7/2025, passed in WPC number 9023 of 2019 by the learned single judge, Your Lordship, whereby the advertisement for the post of English department was considered to be for the unreserved category, but the same was in reserved category. And the similar, Lordship, writ appeal is pending before Your Lordship, filed by the director of the BTC. So the same may be clubbed together, Your Lordship.
Can you provide us the number?
Lordship. Writ appeal number 268 of 2025.
Huh?
Writ appeal number 268 of 2025.
you have the order?
Your Lordship. Lordship, the next date is fixed on 10/6/2026, Your Lordship.
Let this case be listed along with WA number 268 of 2025, which is slated to be listed on 10/6/2026.
Lordship, in the meanwhile, a notice may be issued, Your Lordship, to the respondent.
Let notice also be issued in the meanwhile to the respondent. How many?
Sole respondent.
To the sole respondent on steps being taken by the appellant. Steps being taken by the appellant within a period of 2 weeks, within a period of 1 week. Both modes returnable on in the same day.
10-6.
Much obliged, Your Lordship.
Item number 7.
Mr. Das?
Yes.
Yesterday, we had a shortcut argument, and only because the other side was
He was very fair.
he was with you, you did not further argue. When I sat back to decide, then again I saw that there is something in 3(7), something in paragraph 3 subclause 7 of the 6th schedule, which provides the body. Then perhaps with that ground, you will have to argue that this is not the plenary legislative field, therefore no pith and substance would be applicable. ये सब कहाँ बहस किया आपने? You did not argue that, Mr. Das.
Lordship did not hear me. Your Lordship was convinced.
The Attorney General said that yes,
Because
there
the
is
matter
something
is
in the matter.
pending.
There is something in the matter. We can't just see what had happened in that case. The
Plenary
judgment
power is
delivered
not
by
there. That's
Justice
what I
Vaidpait,
said.
that issue is not there.
Yeah.
It's only with, it briefly touches,
Mala.
but then you have to build up your argument.
Otherwise, I submitted my lord that tenure of the council members are 6 years or 5 years. That cannot be, my lord.
You're taking
But that is the
you're
basic.
taking very roundabout way to come to that. Now, the stronger reason you have to think. Anyway, you have done our job. Anyway, we'll see. We'll see. It will take about 1 or 2 days today.
Well,
While I was dictating the judgment yesterday, I thought that it was a hurried decision which should have been argued. You should have been asked to argue that. Anyway, we'll deal with it. Anyway,
In this
Yes.
case, again, the 6th schedule paragraph 12 there. Unless the notification is published, the rule which has been relied on by the learned single judge, which was done in the year 2018 for e-auction, that is not applicable. Here, on the basis of the highest bid, here the BTC has 12 days.
but that was abandoned totally. No,
That was abandoned.
that was abandoned.
That
Now,
was
what right can you, how do you flag a dead horse?
no, that what has happened, we cannot go
How do you
first ignorance of the terms of the statute. This order was passed. Your lordship will kindly see the order was NIT was there. NIT was there in August 25. This was on the basis of the highest bid. The appellant was.
You are completely nobody so far as the first tender is concerned because you never applied.
No,
Thinking.
President. I was the highest bidder.
When the tender was issued,
Yes.
when the tender papers were floated,
Yeah.
which was not an e-tender, which was not by e-document,
Yes.
you were evaluated as the highest.
On the basis
Bidder.
of the NIT.
Correct.
Yes.
So there was no LOI given to you.
His manner that the order petitioner declared
One
highest.
order was not given to you.
He was declared highest. And the BTC has approved it. Page 62, your lordship.
So, but this was abandoned, was it not?
No. Please, subsequently, they are saying that, on 9, 10, 25.
LY was issued to you or not?
Yes, this order was petitioner declared has, BTC has approved it. Page 64.
There is no LOI
Page,
issued.
page 62, your lordship, let me say.
No, you tell us factually.
Page
No,
6.
Now, the work has been retendered, no?
Yes.
No.
The work has
not
been
returned.
retendered.
Not returned.
Lordship.
Yes.
They have not returned.
Yes, I'm asking. Has the
returned.
work been put to retender?
Lordship, since Lordship, the earlier tender process was not in accordance with law as stipulated in Assam Mines and Mineral Concession.
Madam, listen to us.
Yes,
Your officer recommended that cancel this tender.
yes,
Or that it was not e-tender and
Yes.
go for a fresh tender.
yes. It
No,
was,
my lord is
in case
asking-
is that it was allotted to
Just a
somebody else
minute,
now.
my lord is asking whether you have initiated the fresh.
Yes, your lordship, that is done. This case is that your
She
lordship.
said yes.
Yes, ma'am.
They put the
I'm so sorry, your lordship.
work has been put to retender.
Yes.
Now, has it been acted upon?
Instruction, I need to take it.
On the page 65, your lordship will then see. 65, tender was given, petitioner was selected. The executive member can, and he says you give it to two others.
So you have questioned the cancellation.
Yes,
But then in case the
they are
work,
now they.
just a minute, Mr. Das,
I'll-
in case the work tender has been issued,
It has not
then
been issued.
they say it has been completed.
It is done, your lordship. May I take instruction on Monday, done, madam?
In that case, if he is challenging the cancellation of the earlier tender on the ground that under the rules were not published and
Yes.
therefore it could not have been cancelled,
Right.
then perhaps he'll have to complete all others.
Even though go directly alert to the-
What is it talking?
Lordship, he has made,
Another settlement is
Just
also
a
there,
minute.
page 101.
Please make necessary arrangement for cancellation of allotment or so and so. And two, VTC Forest Mahal is respectively to reprocess for tender of the Mahals for allotment. Re-tender for persons. ये दोनों apply किए। Right, because they would have applied against the tender. Anyway, you file your response.
yes. Lordship, he has made a
Person.
correspondence
Other
and
two
a third
persons,
party.
the executive member says you give it to these two.
That we cannot do.
That is what we can. That is what we can in page 65.
Because the territorial council, the autonomous council is not, I mean, they don't know how to
Executive
administer.
is a political person like.
They don't know how to administer. Look at this.
Yes.
Please make necessary arrangement for cancellation of allotment of Mahals.
Yes,
Meaning thereby that up till now, there is no cancellation letter.
no principle.
And by CS comparative statement against file number 1 and 2, BTC Forest Mahal so and so respectively This is a different mahal. This was Forest 26 of 2025. This is a separate, this is a different mahal. And to reprocess for tender of the mahals for allotment to the new persons as appended below. So we take it that no executive member of the BTC would be so naive as to say that to issue allotment for further persons.
But this person has been named already. That Mukut Narjari and Dinesh
Just a
Boro.
minute, Mr. Das. Did you apply for Forest Mahal 3 of 2022? Did you apply for Forest Mahal 322? Well, advertisement was for cluster. You had applied for one particular Mahal. So this Mahal is Forest 26. They can check up the records.
What is the number of your Mohol where you have participated and according to you are successful?
Yes.
What is that Mohol?
That is there, madam. Advertisement is page 57. Bernardis and Mahal number 12.
12.
Mahal number 12.
And EF says you cancel it and give it to that person. Narjari and Sambolo, page 65. And he was the highest tender. BTC has approved.
Are they parties?
Yes, madam.
Yes.
You have made them parties.
Yes.
Lordship, I'll come up with instruction Monday or on Wednesday, Your Lordship.
And BTC
Specific
has approved.
instruction was steps
BTC
they have
has
to
approved
take.
that. And there is no publication or notification in terms of 12A.
We have heard Mr. B. Das, learned senior advocate for the appellant. And MS, we are learned senior advocate for Borderland Territorial Council. Mrs. B. Moyan, assisted by Ms. R. Das. Next, the Divisional Forest Officer, Baksa Forest Division, had issued a notice inviting tender on 25th of August 2025 for settling Sand Mahal number 12 for sand mining contract period for 7 years from 2025 to 2032. The appellant had participated in open bidding process and had been adjudged as the highest bidder. Consequently, his bid was recommended by the bid committee and ultimately approved by the Secretary, Bodoland Territorial Council, and formally communicated by the Additional Principal Chief Conservator of Forests, come CHD BTC Kokrajhar, on 3rd of November 2025, with the specific directions to complete the settlement as per the Assam Minor Mineral Concession Rules of 2013. To the utter surprise of the appellant, instead of issuing the formal work order, the executive member of the BTC, one executive member of the BTC, issued a letter dated 12th of November 2025 addressed to the Additional Principal Chief Conservator of Forests, come CHD BTC Kokrajhar, directing for cancellation of the approval granted to the petitioner's bid and reprocessing the tender to allot the Mahal to one Mukut Narzari, bracket respond number? Respond number 6, who had not even participated in the original bidding. The writ petition preferred by the appellant challenging the cancellation was dismissed. On the ground that Assam Minor Mineral Concession bracket Amendment Rules of 2018 mandate an e-auction and that while a subsequent Executive Council resolution of BTC on 9th of December 2025, an e-auction for all such settlements was issued. In any case, before the issuance of tender via e-auction, the concessionaire would not have been, ought not to have been selected. The further contention of the appellant is that the NIT in which the appellant had participated and had come out successful was issued much earlier than the Executive Council decision. And at that time, there was no compulsion of putting every work to e-auction. So the process in the NIT was the process of floating the NIT was based on then applicable rules. In that case, once the approval had been granted, there was no necessity of cancelling the same and putting the work to e-auction. This is the second limb of challenge of the appellant. M.S. Bhuyan, learned senior advocate appearing for BTC, seeks some time to respond to this appeal. Let requisite affidavit be filed positively by the next date. Re-notify after 4 weeks. Any settlement, however, in the meanwhile, shall be subject to the outcome of this appeal.
Status quo.
They have said it shall be subject to the outcome.
Another link was that this notification dated 2018 will not be applicable to the BTC unless it is published under paragraph 12A. That is very 12A of this.
Mr. Das, learned senior advocate, has further argued that the change in the rules had to be published before it could have been applied.
The paragraph 12.
Under which the earlier NIT was cancelled and the Mahal was subjected to e-auction tender.
Paragraph 12A is very clear. Notification rule.
Correct.
Whatever is there. it has
Even
to be
otherwise,
published.
what kind of tender is this? When you select a concessionaire,
Yes,
or to our mind, that is a bigger challenge.
that is there. What your lordship is not granting status quo, my lord. Yeah, otherwise
I'm not
they
granting
may-
a status quo for
Now
the
new
reason,
government has
for
come.
the reason that we have not issued notice to, let notice be issued. Let notice also be issued to so-and-so, respond number 6, on steps being taken by the appellant within a period of 1 week. Both modes returnable on the same date.
By speed post.
Both modes,
Date to
17th June.
including Dasti service.
17th June.
17th June.
Next, 17 June now.
You have said it will be subject to the outcome of the appeal. Why are you worried?
No, they may just issue.
Item 8.
What do you want from us?
My residential house, my lordship.
What can we do?
Only my lordship, one last item.
I don't understand. What are you asking from us?
We have been seeking that, my lordship. We are ready for one-time settlement because there are lots of other disputes also.
You go before the bank.
We went there, my lordship.
Then why have you introduced this story of, somebody playing fraud in taking
Well,
up
yes,
bank surety? It is not related to this loan.
my lordship. Related to, we have stated, my lordship, related to this loan only. Also, my lordship, we have taken loan for the work, my lordship. And when we submitted the,
इससे क्या मतलब है? You had deposited rupees 22 lakhs as security in the form of fixed deposit
Yes,
with
ma'am.
respect to a contract work.
yes, my lordship.
Now, these are two different things and you have taken loan only for that work.
Yes, my lord, for this work only.
Correct.
Yes,
So
ma'am.
loan you had taken
Yes,
and
ma'am.
out of that loan amount, you had fixed certain amount as surety.
Yes, my lordship.
Correct?
So I want, that should be adjusted and I am ready
Who is
to.
going to order this under Article 226 of the Constitution?
Well, because physical possession has been already ordered. I have, this is my lordship. My
I don't
lordship.
think, despite the fact, I don't know how it has
My
been done.
lordship,
What
kindly see, my
proceedings?
lordship, the dwelling house,
Authorities,
where I will go, my lordship.
where I will go? This answer we don't have. If you start barking before a wrong tree, we can't give you any relief.
Only because, my lordship, my dwelling house, my lordship, one attempt, my
No
lord,
relief
one.
can be had, but I don't think we have not been able to understand what you want.
They are seeking physical
This is for
possession.
Punjab National Bank.
I is not today. This is which order of the very
Let notice the issue 2. Response number 1 to 4 on steps being taken by the petitioner within a period of 1 week, both modes including Dasti, returnable also and so that.
Highly obliged.
Useless petition. Just over.